So, hi, I'm Sue from Parkies and Me, My Journey with Parkinson's. Today it's my pleasure to welcome Louise, who I've known for many years, and she's going to talk about all things legal, predominantly about wills and also enduring power of attorney. Over to you, Louise.
Thank you, Sue. My name's Louise Taylor. I have been practicing law for 35 years, taking a bit of a step to the side at the moment. I'm working as an adjudicator and as a mediator. But Sue and I know each other from the Canterbury Western Welfare Guardian Trust, which we were both on together. So that's how this link happened. Very happy to be here.
Let's start off. Who needs a will and why? That's a good starter, I think.
That is a good start. Look, there's an arrangement in place for those who don't have a will. So it's called the Administration Act, and that essentially dictates how your assets and liabilities will be dealt with if you don't have a will. So if you die without a will, we call that intestate. And so there is an arrangement in place. And the Administration Act has got a list of people who will get your estate in the event that you die without a will. The problem is that for a good number of people, that list is not what they would want.
Mm-hmm.
They would want their estate to go to somebody else. So in those circumstances, you will need a valid will to the High Court know I've made my own arrangement and this is how I want it to be. So the purpose of a will is so that your voice can be heard when you cannot. And it's to avoid being intestate and having the government essentially determine where your estate goes.
Mm-hmm.
The other thing, if you don't have people in your life in those particular categories in the Administration Act, your estate will go to the government, will go to the Inland Revenue. So most people find that a good reason to have a will.
Yeah, I certainly think they get enough from us when we're alive, let alone gifting them something at the end.
Totally. Could not agree more.
So I'm just wondering, I've recently retired as a social worker, which you will know, Louise. And in my time as a social worker, I've talked to many people about wills and about enduring power of attorney. So I'm having trouble with my words. There is a perception that these things are difficult documents to set up and very costly.
Yes.
What would be your take on that?
Yeah, I agree with you. That perception is out there. And they have got better. If we just look at wills, they've got better over time. They used to be never especially complex, but there were fish hooks in there, and you don't know what you don't know, and they were pedantic. And to be fair to the High Court who grant probate on a will, the person is no longer there to tell their side of the story. You only have a document representing that person's wishes. So it is an important thing to get right. But for decades, people have been saying it's too pedantic. It's very clear what this person wished to have happen. And so we want everything lightened up. So it's been lightened up and it's been loosened up. There certainly is no requirement to have a lawyer write your will for you.
Okay.
There's quite a few places you can get a will kit from for a pretty reasonable amount of money. And you need two people to sign it at the same time as the will maker signs their will. Me signing it, I need two people over 18 who are not bankrupt and who have cognitive capacity. They witness my signature, I witness their signatures, and that's what's required.
So when you say they're available in a number of places, what sort of places might they be?
Wills have one, and I'm pretty sure there's some online ones.
Okay.
And the Whitcoulls one is actually pretty good. And I imagine the online ones are as well. The main thing I would encourage people who are doing it by themselves to think about is be very clear in what you want. So if, for example, you have got 3 sons and 3 daughters, if you were to write in your will 1 car to each son, and you've got 3 cars, that won't be valid.
Okay.
Because you can't work out which particular car to which particular son.
Okay.
And likewise, if you write, our daughters are to each select 1 painting,
yeah,
it won't be valid
because we don't know
what painting for what daughter. So it is, to be as specific as possible. And things like paintings, cars are easy because they've got registration numbers, but things like paintings don't. So you can even put a photograph in there of what painting you're referring to, or just be really clear, the photograph with 3 roses and a blue background that previously hung in the dining room is to go to Marjorie. It
So,
happens a lot with jewellery. My daughters are each to choose one piece of jewellery. Not valid. We don't know what piece of jewellery is going to what daughter.
okay.
So that's probably one thing. And another thing which probably would be wise for you to engage a lawyer about is if there is a situation in your family and you don't wish to leave your assets equally among your children. I'm not saying that can't be done, but it is something that will need to be very carefully ensured that, yeah.
Sorry. So, Louise, I'm just wondering, talking about that situation, or families can be difficult things, as we both know. And I'm
Very
just
much.
wondering what would be the legal standing if, for instance, you had 4 children and you think, I don't like number 4, whichever ones they are, say the youngest, and I'm going to write them out completely, but the others
Yes.
can have everything. What might happen? Would that be
Yes. Yeah. And look, it would be contestable. We have a legislation called the Family Protection Act, which gives a moral right to children to be able to claim against a parent's will if they believe that they've been unfairly treated. Even apart from the fact of whether that is likely to succeed or not, the fact of that child making a claim following the death of a parent against their siblings is incredibly damaging.
Yeah.
Obviously, something was a bit unusual in the family to start with. But so when I've been in legal practice, quite often, if let's say you've got 4 children, you want to leave one out. And your reason is, for example, that that child has got a very significant addiction. And during that child's life, you have paid for 8 stints in rehab and given them a lot of money, and which you haven't given equal amounts to the other 3. And it is your true belief that giving that child further money in your will would be unfair to the other 3 and would be used to further their addiction or make them more vulnerable in some way. It'll probably survive a family protection claim, but it will need to be carefully drafted. So those are the situations where I think, yeah, a lawyer would be a good idea.
I was just wondering, another thing that I've had happen over the years is a husband or wife saying, I'm their wife, I'm their husband, therefore I can make decisions for them. What's your take on that?
A wife or husband saying, I'm the wife, husband, therefore I can make decisions for them. Is that right?
That they have a legal right, they usually say a legal right to act on that person's behalf. And
They do
they
say
could
that.
say, I talked to my husband and he said Jimmy's not to get any money out of the estate. And where do things stand on that?
No, absolutely not. The fact of the person being the spouse doesn't add any gravitas to it at all. If that person who received that information, and bearing in mind at that point it's secondhand information, but may be able to testify in court for a family protection claim. But in and of itself, it has no legal bearing, it has no weight. It could just be a piece of evidence.
True.
You often get, I think you'll know much better than I do, Sue, but in hospitals, you often get spouses proclaiming to be able to speak for the other simply by the fact of marriage. That's not how it works at all.
I have sometimes flippantly said next of kin means next to nothing.
Yep, you're exactly right. Next of kin, generally in a hospital setting, as my understanding is, means legally absolutely nothing, but it can give treating teams a first port of call, but that person has no legal right to speak on behalf of the other person. And it can just sometimes help the team to work out who they might go to first, but it doesn't give you any rights in relation to anything.
Okay. Now, I was just wondering, you were talking before about items of jewelry or vehicles or any of those things. I had a situation in my family recently. We had somebody pass away, and she wanted various things to go to her daughters and myself and others. And she was told that she didn't necessarily have to put it in her will, that she could just write almost a letter or something saying, I want Sue to have this, or I want so-and-so to have that. Does that have legal standing, or does it have to be in the will?
It's a bit tricky. That's technically what we used to call a codicil, which is an addendum, an extra little bit. Honestly, the safest thing is for her to distribute those things while she is still alive. And a lot of people are doing this. Lots of reasons. They can see, I guess, they can see the joy on the face of the recipient for themselves. It is very clear where it has gone to. And yeah, I do know of quite a few places or people doing that now. If you a codicil or any part in a will has to have the same signing requirement, so it would need two people over the age of 18 who are not personally benefiting to sign it. The problem would be if you did it like that, and if there was something inconsistent.
Yeah.
So if in the first one it said April, May, and June are to each choose a piece of jewelry, then the second one says April's to have my sapphire ring.
Yeah.
Then later on there's a dispute, and April says, I actually want the diamond ring, and June says, well, actually, she said the sapphire ring. You sometimes, if you have to be a bit careful if you've got like overlapping documents like that. Sometimes it is easier just rewrite the first one. So, the answer is technically yes. Just have to be very clean and careful that those documents match up and join up. You don't, because inconsistencies create potential for problems, and that whether they turn into problems will depend on the personalities and the amount of function in the finale.
Actually, what you were saying about giving away things while you're still here to people you'd like to have them. I had Christmas with my grandchildren and my children very recently, obviously, and I had been collecting some bud vases that you just put one flower in, and I got each of the girls to choose a couple of those to take away now so that they can enjoy them. And we enjoyed getting some roses out of my garden that they would put in those vases.
I think that's, yes, and you've got that special memory now.
Yeah.
And they've got a special memory, whereas if it comes as a result of a will, it's overshadowed by the sadness of the circumstance.
And I checked in with
they've got that memory. Yeah.
Yeah, I checked in with them and I said, do you think this is a sad thing to do or a nice thing to do? And they said, we think it's a nice thing, Nana. And I said, in the future, when I'm no longer here, and somebody said to you, would you like to get something out of that china cabinet? You probably say, it's the last thing I want to do. I've just lost my Nana. So this is a nice way to do it.
Yeah, exactly. And then they've got the memory, they've got that same physical item, but they've got the memory of picking the rose that went in it with you, and all of that comes together into their mind. But yeah, it's something I have seen quite a lot of lately, and I think there's something to be said for it.
Absolutely. And I said both to my son and my daughter about it, and my daughter could see that it was a good thing for me to do that with the girls, but my son wasn't quite ready, and that's okay too.
Yeah, sure, absolutely. And that's fair. I guess some people may see it as morbid. Maybe he's just in a different place at the moment.
Yeah. And that's all good. It's rare that we get our family together at all, let alone Christmas, with both my kids and all my grandchildren. So I thought it was a golden moment to introduce that idea into the family.
Totally right.
So that they were aware that was something that I'd like to look at. Getting back to wills, how long should it take to settle in an estate if there is a will, and how long might it take if there isn't?
Okay, so if there is a will, and this is going to depend on the complexity of the estate. If, for example, there's trusts and company shares and all sorts of things like that, things take longer. So if there's a will, a process called probate needs to be gone through. So that will has to be sent to the High Court, who go through a number of processes to say, yes, the will is valid. And then to the person who's been appointed as the executor, which means the person who's going to do the job of getting all the assets in and distributing them in accordance with the will. So the executor cannot do anything until that probate is granted. All probates come through Wellington now, and but luck of the draw, sometimes you can get them within a week, sometimes they can take 10 weeks, but absolutely nothing can be done in that time. The exception would be if you had a situation where, I'm thinking of farming situations where I had one where cows were on land in a terrifically bad drought. The cows were part of the assets in the estate. They had to be moved off the land, and we had to go to the High Court and get orders to do that urgently. So on the whole, you do absolutely nothing until you get probate. Once you get probate, the executor, which might be a professional, might be a lawyer, an accountant, or it might be a family member or a friend, then has the job of essentially working out what does the estate look like, what are the assets of the estate, And of those assets, which ones need to be liquefied? Which ones need to be turned into money? So are there properties that need to be sold, shares that need to be cashed in, things like that, and then that's to be distributed as money? Or is that property going to be distributed and held by, then owned by the beneficiaries? The job of the executor is not an easy one, and it's made more difficult if you've got beneficiaries who are saying, I want my stuff, I want my stuff, I want my stuff, because the executor is personally liable if they make a mistake. So I'd encourage beneficiaries who are listening to give some grace to the executor. If it's not a professional executor, they're not being paid for this. And there is actually quite a lot of responsibility that comes with it.
Yeah.
If they, for example, were to distribute funds to child A, there's 3 children, A, B, and C. They distributed a certain amount of funds to child A. It later turns out that those funds were for child C, or a proportion of them are, and A spent it all at Disneyland. It's the executor that's got to pay C. It's not a job to be taken lightly, and it's one where I think sometimes beneficiaries don't actually realise the level of responsibility. Executor cashes up the assets that needs cashing, and then the process is then distribution. The issue that executives have is that people have 12 months to potentially make a claim on that estate. We were talking before about a child that's left out of a will, or if there's somebody else who was owed money by that person under a contract, then they've got a right to claim against that will as well. So if the executor says, okay, we got probate week 6, week 7, I started distributing the estate. Now, if a successful claim is made against that estate 9 months later, it's the executor who's personally responsible for meeting that claim.
Gosh.
So executors will very often, I never distributed an estate before 6 months. And then at 6 months, only if I have no sign whatsoever of anything, child popping out of the woods or anything like that, and if I get everyone to sign a disclaimer. So take a lot of care distributing assets under an estate. Family arrangements are now much more complex than they were, with blended families and things. Make our lives richer in so many ways, but also more complex. It's something to be wary of if you are a lone executor distributing an estate where you've got a complex family, where not entirely sure that all of those, that everybody thinks the same and that all relationships are fully intact. Just be aware of distributing within 12 months.
Cool.
One more thing about wills, though, do take care if a relationship breaks down, do make sure that you review your will at the same time.
Very good advice.
Okay, that's it.
So this has been Sue for Parkies and Me, my journey with Parkinson's. Thank you, Louise, for your time. And kia kaha, be brave, be strong, be you.